and welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss an issue which sort of is the heart of corporate and business India, that why GST or taxpayers' bank accounts are being attached where they are not given an opportunity for a hearing. A notice is issued and then the attachment happens. The account is basically frozen, basically throwing the person out of business. He may not be able to pay salaries, pay EMIs, and the impact many times more than the owner is for the employees who work for such an institution. What needs to be done so the business community is taken care of in a way that the business doesn't itself stall? That is very important, and that's why I have with me two eminent panelists who will bring forth what can be the way ahead if we have to encourage people to do business in India rather than throwing a spanner in a vehicle which is running and bring it to a dead halt and making everyone astride it fall and be injured. I have with me senior advocate Sachit Jolly, who joins me from the city of Delhi. Good to see you, Sachit. Thank you for your time. I have with me Advocate Aditya Ajgaonkar, who joins me from the city of Mumbai. He practices at the Bombay High Court, also at the Supreme Court. You see him speaking on a lot of tax issues. Good to see you, Aditya. Appreciate your time. At the outset, let me request Sachit to make the opening comment on this issue. Over to you, Sachit.
Tarun, thank you for having me today. Look, I share the agony of people who have gone through it. But this provision really, which is in GST as Section 83, which is the draconian section we are referring to, is borrowed actually from the CPC, has its genesis also under the Income Tax Act. But it has never been used in this bizarre and brazen manner under 70 years of the Income Tax Act. We have it in the form of Section 281B. It was there earlier as a Section 241. In fact, very interesting, Tarun, that under the Income Tax Act in 1989, this provision was deleted because of the flagrant misuse by the income tax authorities. We got rid of it. It was rebrought into the act in income tax in 281B, then rebrought in 241A. So it's been quite a mess. But we've never seen this kind of aggressiveness which we've seen under GST and under Section 83, that anybody and everybody who's dealt with somebody who has a problem or who has had an issue with some fake input GST, that person is also, his accounts are attached. So, I may be a completely clean and kosher guy, and I have dealt with somebody who may have done something wrong, which I don't know, but my accounts are frozen today and hampering my payment of salaries, wages, etc. It's actually draconian. See, the sad part is that both the Supreme Court in that Radhakrishnan decision of Justice Chandrachud, as well as the CBIC, recognize that this is a draconian provision, recognize that there need to be safeguards, but there are really no effective safeguards. So, while of course we'll dwell what best we can do, but the fact of the matter is that today we have a provision which is being largely misused by the authorities in the GST department.
And in fact, this issue has become a very hot topic in the business circles because the cascading impact is so huge that one businessman who gets hurt then speaks to 200 others and they get scandalized that, what is the prospect? I'll get Advocate Aditya Asgaonkar in at this point for his opening comment.
Thank you, Tarun. Thank you, Sachit, for explaining the dilemma that a business faces so well. This is a classic case, I think, where there is a danger of actually the goose that lays the golden eggs being, taken out of the picture completely. After all, what we are talking about is a tax statute. Tax can only come if business happens. And if my working capital is all frozen up preemptively, I mean, without there being any demand upon me, I think that can have disastrous consequences, not only to me, my business, my employees, but up and down the value chain. Because money is the oxygen of business. If I do not have access to my own funds, I cannot do anything. I think I'm, uh, worried about everything if my bank account statement is frozen and I do not get to oppose the freezing until post facto, right? I can only challenge it after it is done in another form that is prescribed under the GST, and I have to make a representation in that form. And then that form has to be disposed of by a reasoned order by the authority that the commissioner that does the freezing. And surprisingly, there is no outer limit today prescribed in how long the commissioner can take to dispose of my order. Now, the preemptive freezing can be done for 1 year. How long will the commissioner sit on my representation? I do not know. But there is a limited period of time which I have to make the representation, and then he can take his own sweet time. And I don't think that it is normal practice for the commissioner to take that long to dispose of the matter. If a representation is actually made. But I do have my doubts as to how efficacious this becomes. Every time a provisional attachment order is passed, clients panic. I have had clients who had accounts frozen for 4 years. The final order of adjudication is passed. They've asked for defreezing to be done. No defreezing is done. They have to file an appeal for which they need a pre-deposit for which they need defreezing. So it's a vicious circle. And, I think it just can cause a lot of problem if cognizance is not taken of this by the department itself. I mean, the courts of law will obviously make sure justice is done, but this is something that perhaps the legislature, perhaps the executive themselves need to be cognizant of, and bring in some more safeguards. Like Sachit said, Income Tax Act removed this because it was a draconian provision. I mean, I think it merits consideration.
Thank you, Aditya. One very quick question I had in my mind, that is it proportionate to freeze the entire account for a liability which may be much smaller?
The problem is there is no question of proportionality here. What basically the act says is that you can preemptively freeze these accounts for making sure the interest of the revenue is protected. Now, this is a very broad statement. What is the interest of revenue? How much is the interest of revenue can only happen after adjudication. How, because the language is so broad, I've had reasons recorded for freezing being say X crores, but when when I make an application and when we went in a writ in the High Court, the department came back saying that the actual liability is 10x crores, which we are investigating. Therefore, the interest of revenue needs to be protected. So I mean, it's all very
No, wait, Aditya, wait. I'll go to Sachit. Quick from you. So the objective is to close the business in the pursuit of revenue. Is that the objective? Because if I do this, then the business is automatically going to shut down, isn't it?
Arun, I will step in here. I'll use a phrase which Dr. Manmohan Singh used when demonetization was done. He said this is organized loot and organized plunder. Organized
Organized
loot,
route and
legalized
legalized.
plunder. Now this provision is nothing short of that. I mean, I don't know whether demonetization was that, but this provision, you're absolutely bang on point. That this provision, what it does is it allows, and there is a departure from CPC, there is a departure from the Income Tax Act here, because under Income Tax Act or CPC, you can't attach bank accounts. You can provisionally attach non-current assets, fixed assets, so that the revenue is protected. You could never attach bank accounts there before a demand is raised. Over here, even before a demand is raised, and Aditya has made this very valid point, you can attach a bank account and then, if I go to the court, you turn up and say, look, I'm investigating a much larger scam. Now, you may be investigating a larger scam, but in the attachment which you do in my hands, you can only at the most recover my part of the tax. So your attachment has to be restricted to my part of the tax, which you should quantify. And in fact, just to complete on that sequence, there is a very interesting decision in the context of Section 83 of the GST Act from Gujarat High Court. It's called Valerius. Now, there the High Court laid down a very important parameter. He says, although the section requires subjective satisfaction of the officer, but it must be based on objective material, and that objective material must show that the person, the taxpayer concerned, is about to dispose of the money or the assets in order to frustrate the tax claims which the department may have. Now, if you apply that test, I can say with surety 99% of these attachments will go. But there is no, I mean, like Aditya said, that my hearing comes after the attachment is done. Now that really can't survive. So the first safeguard which I believe should be brought in is a pre-decisional hearing. And I would, also say that we have something similar under the Income Tax Act, where you have an approving panel. We had something called an approving panel for GAR, the General Anti-Avoidance Rules, which is manned by a retired High Court judge. So you have somebody to interpret and apply these strict measures, that you can't really go and attach somebody's bank account in a preemptory manner. That needs to really go.
But tell me one thing, Aditya, I would need you to come in here. So in the pursuit of revenue, unintentionally a business closes down?
No. So, Section 83 is very interestingly worded. Okay. It says where after initiation of any proceedings under Chapter 12, Chapter 14, or Chapter 15. Now, proceedings, if you actually look at Section 6, the dual proceedings issue that had plagued, actually still continues to plague dual jurisdiction, state and center, which finally accumulated into Justice Pardiwala's judgment in the case of armored security. Now, proceedings is said to start after issue of show cause. Okay. Uh, that was a takeaway I had with it, though it was with respect to Section 6, not with respect to Section 83. I believe if we can read that protection here, saying that you have to issue a show cause, there will be an amount quantified under that show cause. Because usually show cause quantifies an amount. If my provisional attachment is to be capped at that amount, then perhaps, one of the safeguards, I mean, this is a suggestion, this will be, taken up informally, or maybe the board could issue some direction in with this. Then perhaps it could be justified saying that here I have issued your show cause after doing my investigation, thinking that X amount is due for you. Because you shouldn't funnel away or get rid of that X amount, now I'm provisionally attaching your bank accounts for 1 year. I think that
But
could
tell
be
me
a
one
fair.
thing.
Sorry.
I have as a business owner ongoing compliances,
Yes.
salaries, the statutory dues,
Yes.
PF to be deposited. All that gets my payment to suppliers, my checks issued. All of that gets affected when this happens. So does the department, and you tell us, and the business guys who watch this, need to specify this minimum account that business survival requires? So if you have attached 1 crore, if 50 lakhs out of it is necessary for business to survive, will that be defreezed or everything is frozen?
So, see, what should happen and what happens can be two very different things, when the law allows it. We have even see cash credit accounts being attached. And if you actually go look it up, there are a lot of judgments across high courts where cash credit facilities that are not really bank accounts owned by the business, which are actually temporary loans, have also been frozen. Now, the question about, how much money is required for the business to survive would all depend upon the show cause notice issued to you, very honestly. If you have 1 crore in your bank account, say, and if the show cause notice in the proceedings, according to me, it just says 30 odd lakhs, then 30 odd lakhs would be fair. But the GST department is primarily concerned with making sure you don't run away with your liability. See, the entire point of Section 83 is to make sure that if liability crystallizes against you, you cannot, in the interim period after issue of proceedings, until the accumulation of those proceedings, arrange your affairs in a manner that you run away from the liability. As of today, your question whether certain amount that is required for my business to run, there is no provision for that. Because I mean, if we are assuming all your bank accounts are frozen, then you are anyways in deep trouble with the GST department, because that means that the amount under investigation is greater than your entire cash flow. So, I mean, that would be pretty much a very concerning aspect. But no, today the law does not really provide for a certain amount to be kept aside for your day-to-day running of business. Second issue would be how much would you quantify as day-to-day running of your business? Would that include your salary account, your loan accounts? What about the expensive car that your director drives? I think this gets very argumentative with respect to running, and that is what the department's always concerned with. The interesting aspect, and I think the most important safeguard that is there in this section now, is the fact that this provisional attachment can only last 1 year. And now the Supreme Court in Kesari Nandan Mobile has settled it, saying that it cannot be renewed. Earlier, what used to happen is, as I said, I've had client where 4 years attachment is still continuing. Then 1 year used to get over, they used to issue a fresh provisional attachment. And then that second one used to get over. If that adjudication hasn't happened, they would have done it for a third time. That would block away a large part of your funds for a ridiculous period of time. So, Kesari Nandan Mobile judgment of the Supreme Court, it is very, very recent. It has just come out. And I think it is fantastic because it says that if you allow these provisional attachments to be renewed, then you're basically taking away the protection that is built into section 83(2) and pronouncing it dead letter. So I think that is very interesting. So it's just a function of what we have to do as lawyers, that the Supreme Court has to read in these protections into an act where these protections already are built. So I think the law will evolve. But as of today, if the question is that what if I have 1 crore in my bank and I needed to run my business and the department decides to freeze it? No, I don't think the department's going to let you off that easily and release a part of it just so that you can run your business for a year.
Okay, point well taken. Senior Advocate Sachit Jolly, one thing I want to know from you, is it the commissioner who decides or is it a committee of 3, 4 people who take a call when a business has to be frozen?
Well, as of now, it's the commissioner who does it. But I would.
And he has to give reasons in writing?
He has to have reasons in the file. I mean, that's a strange thing. Reasons may not be communicated immediately, but of course, you have a right to ask for reasons. Now, I would go a step further, Tarun, I think, because anybody can write any reasons. These are subjective satisfaction. The law on that is settled. But what I would expect is, because, if you leave it at reasons being recorded in writing, that really means nothing. I think 3 or 4 things, as I would think, should be done, or a combination of 2 or 3 of them. A, you please read in a pre-decisional hearing. If the government is not serious about it, maybe it's time for the courts to step in and say, this is a draconian measure, read a pre-decisional hearing into it. Point number 2, as Aditya rightly said, this provision should only be allowed to be invoked once there is a proper show cause issued. If there is no show cause, one should say no proceedings in that sense are pending. Therefore, there is no computed liability, and therefore attachment is absurd and manifestly arbitrary because there is no amount quantified. So what will you attach? That's point number 2. Point number 3, I think that will be too much of a step, but I think freezing of bank accounts should go as a matter of principle. Even if you have to attach, maybe attach sale of immovable property, maybe sale of some, fixed deposits or mutual funds, etc., but not liquid cash which is running in the account. That power should be taken away. And finally, I believe, like the question which you put to me, that the fourth and the most important safeguard would be that let this be approved. If the commissioner even wants to attach, let this be approved by a higher authority, maybe is escalated to members of the board or an independent authority. Please don't leave it to individual commissioners because they have their targets. Let's not make this a target completion exercise. This is very serious.
You have a very fair point. Aditya, in the cases that you have argued in these issues, do you think it's at the whims and fancies on which commissioner's table your file has landed? or a lot of thought is given before the attachment or the provisional attachment is effected?
See, I will not be able to tell you whether answer your question straightforward because you don't get a pre-decisional hearing, as Sachit said. So I really do not know when my bank accounts are frozen, whether
No, no. So you mean without a hearing opportunity, your account is frozen?
yes, of course, that is the most problem, right? You get to object to the freezing after the freezing,
So no opportunity for hearing.
not when the freezing is done. And this is very interesting because
But how
what
is that fair in any? How is that fair?
because the idea behind it is that if you get a pre-decisional hearing, what if tomorrow you siphon off before your hearing? Suppose the department tells you, come before me in 3 days and get this done. And what if in those 3 days I empty that account? That seems to be the rationality behind it. Okay, I'm not saying fairness about it. That seems to be the rationality. But when it comes, I'm more concerned with the timelines. The fact that one part is that you attach it, you hobble my business, that is one aspect. But the timelines are very important. There has to be a timeline within which my objection to this attachment should be considered. In fact, I would suggest why do we need, time? Why do I need to object to my attachment? If you are preemptively freezing my books of in my bank account, then you issue me a notice no any which ways as a right saying that if you have objection you come out here, I will give you a hearing. I have preemptively frozen your account to ensure today that you don't siphon off any money, and tomorrow if the order of adjudication comes against you, I have money to realize because the government deserves its due. But I'm thinking, why should I have to object? Why not build in a protection in the act saying that if a freezing is done, you issue a show cause tomorrow saying that if you come out here and object if you want to, and I will dispose it off in so and so days. Now, there are judgments of the Bombay High Court that really help the assessees. But again, what happens is these things only come up when challenged. Like in originative trading, the Bombay High Court held that the commissioner should provide a copy of opinion or reasons found by him while ordering the provisional attachment. In Patel Engineering, the Bombay High Court is somewhere else held. They were very interesting. They said that protecting the interest of revenue should mean that unless the provisional attachment is not done, the interest of the revenue will not be protected. Now,
You
that is
said
a very
Patil
high bar.
Engineering, Patil Engineering, and before that, which point?
Tarun, I cannot hear you. Sorry. It's Patil Construction and Infrastructure Limited. Sorry. I stand corrected. And what it basically
And
says is, hello, can you hear me? Yes.
yeah,
What
you
is
are audible. You are audible. I'm saying that
yes.
Patil Construction. You referred to one more judgment before that, just before that.
Originative trading and Patil Construction and Infrastructure.
Okay.
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 Now, what Patil Construction says is very, very interesting. It goes into Radhakishan Industries and it says the expression necessary to do so for protecting the government revenue implicates that the interests of the government revenue cannot be protected without ordering a provisional attachment. Now, if the bar is set that high, then I think then 83 is justified. But then the bar needs to be set that high. It cannot be at whims and fancies.
Go to say Sachit at this point. Sachit, one thing I want to know from you now: if you have to amend this and allow the promoter to be given a hearing opportunity before the attachment, then this law needs to be amended by Parliament. Will it be done by an executive order? What is the process?
See, ideally it should be by Parliament, but it could also be through a board circular.
Board
Look, you don't
circular.
have to. You can do it. You can say that as a matter of, relaxing the rigor of the provision, I am as a board directing that all commissioners will give a pre-decisional hearing. Now, and I also want to address this point which Aditya raised that, what if you give a notice and somebody runs with the money? Well, let's be honest, the long arm of the government cannot be scared that a taxpayer has taken away the money. I mean, you
Yes.
can't
There are
start
other
with an
agencies now,
assumption.
if for that purpose. There are other
You
agencies come.
yes, and you can't start with an assumption that all taxpayers are frauds. And I think that should go. You must trust your own taxpayers. If you don't trust your taxpayers, then you will have these kind of provisions which will stop the business and which will stop the food chain supply.
Point very well taken. I'll go to Aditya at this point. Aditya, one thing, you also concur that the board circular suffices for this, or you need to go through the whole rigmarole, you go to parliament, get the law amended?
See, I am telling you, in my interpretation, the form DRC 22 that is used for this provisional attachment is ultra vires the wording of the section. In a way, I think that can be argued because I've got DRC 22 ahead of me, and it not only says, it is a standardized form. GST has standardized forms, and it's very interesting. It says no debit shall be allowed to be made from the said account or any other account operated by the aforesaid person on the same PAN without prior permission of this department. That means there is a complete freeze, not only on the bank account, that one bank account, but with respect to the entire PAN. So proceedings could be with respect to say 20 odd lakhs. I may have 2 crores in my accounts which are attached to my PAN. DRC 22 itself says that no debit will be allowed for any accounts attached to my PAN. And I think, somehow I think this goes beyond what the section says. I'm sure by the smile on Sachit's face, he will be testing it in court. But, but I think it's very interesting, that the act says one thing, the rule says one thing, but the form goes on a whole different tangent. And usually, courts penalize the department for not adhering to forms. Assessees also are fairly desperate. If they don't go as per form, we will say they have not gone as per form. But if they go as per form, my entire bank accounts with respect to everything to do with my PAN, everything is frozen. Blanket freeze. If this notice is issued as it is. And I think that is a big problem. There has to be
One final comment from each one of you, because we are almost out of time on this one, and we're going to continue in the next show on this topic. But one final comment from Aditya, then from Sachit Jolly. Aditya, what can you give me a clear 5-line opinion of yours on promoter being given a hearing opportunity before freezing his account? If you were to be asked an opinion, what would you give as an opinion?
I would say that holding my entire bank balance ransom for something that may be related to one of my business entities for a smaller amount would be very unfair. Therefore, if at all you want to stop all transactions, everything to do with my PAN, then yes, I deserve a pre-freezing hearing in adherence to everything with the act, even as the act as it is. Act is as it is. I'm saying it seems extremely unfair today that all my transactions, everything linked to my PAN can be frozen today based on one order, and that freeze status will continue, that provisional attachment will continue for 1 year. 1 year is a very long time to leave me penniless.
Point very well taken. Sachit Jolly, your closing comment.
I would put it in two buckets, Tarun. One is certain things which can be done immediately, which are that the board, by way of a circular, can introduce a pre-decisional hearing, which is we don't require the parliament. The second thing which the board must step in and immediately say is introduce the principle of proportionality, that your attachment will not exceed the estimated amount that you think is recoverable from person X. Those things can be immediately brought in right now. You don't need an amendment of law. The larger question is, can bank accounts or should bank accounts ever be subject to a pre-assessment attachment? I think that's a larger question. And second larger question is, should we have an approving panel to approve any proposal for attachment of bank accounts? That I think will require a legislative amendment. Those can be parked for future, but I think these two should be brought in immediately.
So should a panel approve the attachment of account? That's the larger question. It was a very interesting discussion. This is at the heart of corporate India. Be it a business doing a turnover of a few crores or maybe a few thousand crores, everybody could face this, and it could literally throw a lot of people jobless. That is more important. The promoter many times can still get away. He will have something of insurance, not the people who actually work for a salary. I would like to thank Advocate Aditya Jankar, who joins us from the city of Mumbai. We have Senior Advocate Sachin Jolly Sainik joining us from Delhi. Appreciate your joining us and some really good deliberations made today. Look forward to the next one on this. Thank you so very much. Thank you.
Thank you so much.
Thank you. Thank you.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.